Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. I owe you guys an update on the status of my Section 74 application, and just a little bit of a recap in case you're unfamiliar with this issue. Earlier, the Canadian government banned a whole wide range of firearms, including the AR-15, but not limited to. They banned a whole bunch of other stuff. And after that, the registrar sent out a letter saying, hey, we think that these registration certificates correspond to a banned firearm, and so those registration certificates are nullified. Later, they updated their terminology to say administratively expired in the court process, but the initial letter said nullified. Now, what they didn't do is they didn't send out a notice of revocation as required by the Firearms Act. And so I brought a challenge, and many other people brought a challenge, but my main issue on this was to say, hey, listen, you guys have to comply with the law. The law says if you are revoking a registration certificate, you've got to send out a notice of revocation, and this is, the process you have to follow. Anyway, unfortunately, what I have today is not good news because the court has decided that there is not jurisdiction to hear this in a Section 74 review, and so they've struck the application. So that's it. We're done. We've lost. Of course, I'm kidding. This is not the end. This is really an expected, well, I mean, I was hopeful that we'd win at this step, but it was not unexpected that this is going to be an issue of huge importance and one that ends up at a much higher level of court. So regardless of who won here, it was going to get appealed, and it's going to get appealed. I'm not giving this up at this stage. So that's what I'm going to be working on next, is getting the an appeal together and fighting this on and on. The importance of this decision is huge because as gun owners, we've seen that the chief firearms officers in various provinces and the registrar of firearms have been engaging in this tactic where they say, oh, we're not refusing you, we're just not processing your application, or we're not refusing you, we're just granting you something else. We're not, this kind of linguistic game has been a constant problem for gun owners. But it's not going to end with gun owners because this is really administrative law issues here. And administrative law covers a whole lot of interactions that people have with the government. I don't know that this is something that's been really considered, but there's no way that this argument, if the government of Canada succeeds with it here, ends here. It's going to end up being seen in, for instance, immigration law, where they'll say, hey, listen, the law says that you're ineligible to remain in Canada if you are the following things, and we think you're the following things, so you're ineligible, and off you go, and we didn't even make a decision. So the potential impact of this decision, not just on firearm issues, but generally, is incredible. It's huge. There should be administrative lawyers having a pants-shitting, terrified moment about this, because this is really the place where gun owners are going to potentially be used as, the issue that they can wind back a whole lot of administrative law principles over if they get their way. And I'm hoping that they won't. This decision, in my view, goes against a whole lot of administrative law principles that have been long-standing, including that the failure to give reasons is itself a reviewable decision. Now, normally I would stop here and go through this case line by line and sort of discuss things in detail with you. I'm not going to do that here. And the reason why is because, as I said, this one's not done. This one's going to end up at much higher levels of court. So I don't want to really tip my hand at this stage. I'm going to say I disagree with this decision and that there's a whole lot, there's going to be several grounds for appeal that I argue. But at this stage, I'm still formulating that to lay out into a formal court document, and I don't really want to sort of tip my hand here. This is also a bit of a tough case to discuss because although I think that the judge got it wrong, this is a judge I have tremendous respect for. It's a judge who is, he's a really careful thinker. I think he missed some things on this, and maybe that's on him, maybe that's on me. Maybe I didn't, successfully argue the point here. But, I mean, I thought I did a good job on this one. We'll just have to see. Quite frankly, this is going to be a really big issue for Canadian gun owners, not just about this ban, but about things going forward. especially because they keep updating the list of what they consider to be variants. And, if that means that they can just keep saying, oh, well, you don't have a right to a judicial review just because we've decided that your registration certificate is canceled. There isn't going to be anything left of Section 74. This could be the end of Section 74 as an available review process. And that's something I really want to see not happen, because Section 74 is tremendously important. And that's Section 74 of the Firearms Act, the process by which you review a decision of the chief firearms officer or the registrar to refuse a registration certificate or to revoke one. So there's a whole lot of things I got to think about in terms of how I want to bring this, but I'm not giving up. This is not the end of this. This is going to continue. There's a bunch of arguments that were made that didn't seem to make it into the decision here. Some of the places in the decision where they said, hey, this is what the applicant argues, were not actually the arguments that were made. So, yeah. Anyway, this is a setback. It means that we're coming at the appellate process. You always want to, in an appeal, be coming to the appellate court as the previously winning party. That's sort of a tactical advantage. It's having the high ground. Because at that point, you don't need to say, hey, listen, we should have won at the original decision level. You also have the advantage of being able to say, listen, there's no reason to overturn the previous decision, that previous decision is acceptable or even just not wrong enough to intervene in. So there's this kind of tactical advantage to that. And also there's a tactical advantage in the sense that you've got the previous decision and it lays out reasons for, why you should have won at the previous level. So that's where I was hoping to be when coming to Queen's Bench. The other issue is that this novel argument by the Federal Crown, and I say novel argument because notwithstanding the fact that this isn't the first time that the registrar has had to deal with the issue of, oh, we think a bunch of guns are banned, there is no prior case law that I could find or that the registrar's counsel, the Federal Crown, could find to show that this process has ever been followed before. So this is really a new invention, but it creates a real procedural morass where it's unclear as to what happens. And there's a very real risk that the court could end up deciding that this whole issue becomes moot because we're running out of time here in terms of the amnesty order. And normally the Section 74 process provides itself its own sort of amnesty, allowing for essentially keeping the firearms in order to challenge it to prevent the whole issue from becoming moot. So if that's lost because of this new argument that, again, the courts have never entertained before, and I don't know why this decision doesn't look at any of the prior case law before this that address similar issues and heard them within the context of a Section 74 review. It doesn't do that here. But essentially their argument is that those protections aren't going to apply. And so what I anticipate is going to happen is they're going to say, hey, listen, you got to turn in the guns because the amnesty is expiring. And then they're going to say, oh, well, you don't get to fight this anymore because now that you don't have the guns, then, the issue is what they call moot, which means that there's no sort of live issue of contention left to fight. So, yeah, I'm not super happy with this decision. As I said, I've got tremendous respect for this judge. I think he's a really good judge, but I think that this was the wrong call. I think that this is a decision that I hope is ultimately going to be reversed, and I'm not done fighting. I'm going to be taking this one all the way. One thing this video isn't, because some of you have asked about this, is a call for donations. This isn't a fundraiser here. I'm going to point to my Patreon at the end of the video, but I always do that. There are expenses associated with taking these matters up into court, especially as the level of court gets higher, but so far they're under control. That may change if this is going to the Supreme Court, and I expect it will, because the Supreme Court's expensive, and the government, quite frankly, has an unlimited budget, whereas I don't. So I might end up throwing that flag out later on, but not right now. It's Christmas. You guys have your families to worry about. So as much as I'm going to say, hey, here's my Patreon, this isn't a me rattling the cup to keep going. This is going to keep going regardless. So yeah, let me know in the comments what you think. I mean, this isn't the answer I wanted, but it was not unexpected as a possibility. You know, I didn't go into this thinking, hey, I'm going to lose, but I certainly, you know, this is going to be a tough fight. And I think ultimately what we're doing is laying the groundwork for the ultimate fight at the Supreme Court. So thank you for watching. You know, I really do appreciate it. I know there hasn't been as many videos. It's Christmas. There's a whole lot of stuff going on, but there's a whole lot I want to talk about in the new year here. So anyway, thank you once again for watching. I also want to thank, as I mentioned, my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Firearms Association; Mike, Kyle Martin, Jean-Guy Toussaint, the CCFR, and the Canadian Shooting Sports Association; at the $30 level, Sights and Arms Limited and Marc-Olivier Damour; and at the $20 level, Raymond Del McKinnon, Peter Hilger, Matt Ward, Mark Whittington, Jane Babe and Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you as well to all of the $10 supporters who will be in the crawl immediately following. A lot of people are also going to be wondering about the Kukri giveaway. I've selected a name. The email is going out probably right after this video goes up, and we'll see how they do on the skill testing question. As I mentioned, Canada requires a skill testing question, and if they don't get it, I got to pick another name. So we'll see how it goes. But yeah. Anyway, thank you once again. I hope this has armed you with knowledge, and I hope there's some more optimistic and upbeat updates to this one as we go, but we'll see. I've also got some big news that I'm waiting on because I'm waiting for something in the mail. But once that comes in, I don't want to spoil it. I guess I'm being a little bit of a tease here, but I don't want to spoil it. Anyway, cheers.